We all know the ongoing COVID-19 pandemic and the implementation of MCO early this year has badly affected many businesses, including property developers. Often we hear stories about development project has been abandoned due to developers going busted. The home buyers suffers because they need to pay their loans. Yeah, so hi and assalamualaikum to all viewers out there. I'm Azlan Jaiz and thank you for tuning in with us. I'm the moderator for today. Yeah, so today we are going to explore some important techniques of financial and debt management for property developers in a current difficult economic situation. So in our set today, I'm pleased to have two special guests who are practitioners in company debt restructuring. So please welcome Surveyor R.A. Ganapathy Supermaniam, okay, the Key Management Officer of Raiidius, Sdn Bhd, and Miss Florence Wong the Claim Consultant from Reconstruction Consultants, Sdn Bhd. So how are you guys?
I'm very good.
Yeah, so thank you for being with us today. So, okay, for the kickstart, yeah, let us talk about the elephant in the room, okay, the big issue happen right now. So, many people may not realize, but as the movers and shakers of the property industry, property developers themselves having their own issues of problem that they face right now, okay. So, Mr. Gana, so perhaps that you can share and tell us what are the common problems or issues faced by the developer right now.
Morning, Azlan.
Morning,
Florence.
Morning.
Okay. Basically, the problem that being faced by the developers at the moment is that the agreement that they have entered with the purchasers.
Okay.
Okay. The agreement requires them to complete the project within the stipulated time frame. And this is contractual.
Okay.
Okay. And the second issue is commencing work and getting certification according to the stages. So they might have problem in commencing work, getting material and completing as what they have planned.
Okay.
And basically they might be delay in certificate of completion and compliances, handing over vacant possession, and for those handed over units, they might have issues completing their defects within the time period given.
Oh, okay.
And major of all, I would say, is unable to sell the remaining unsold units.
Okay. So, Florence, I mean, throughout your experience as a claim consultant, perhaps I can share with all the audience out there. So, what are the common problems or issues that maybe you have settled before?
So, hello everyone, and then hello Aslan, as well as Mr. Gana. Okay, so let's talk about agreements that that not only with purchasers but developers have with contractors as well.
Okay.
The issues that Mr. Gana had mentioned just now causes the developers to be very bad paymasters because due to issues such as delay of works, and then contractors are unable to commence their work due to the pandemic. All these issues, it causes works not being able to proceed accordingly, and then developers are not able to pay the contractors on time. So they are not able to pay the contractors on time, contractors can't work. And contractors can't work, the project will not proceed. And then there wouldn't be any houses to give to the purchasers. So with all this, it's like a chain reaction that affects everyone. It doesn't just, when it affects the developer, it affects everyone else too. So it's a problem that must be addressed to protect all parties.
Okay, so Mr. Gana, I mean, it sounds there's a lot of issues or problems faced by them as property developers. So what should they do, and perhaps again also you can share with us what are the solutions, maybe you can advise them?
Okay, when you say developers, basically we are looking at two elements here.
Okay.
Licensed developer, which is licensed by Ministry of Housing and Local Government, or KPKT.
KPKT, okay.
And another section is unlicensed developers, which are the commercial developers. So they are not practically regulated under the Housing Development Act.
Okay.
So those licensed developer who has obtained license from Kementerian Perumahan Kerajaan Tempatan, they do have valid advertisement permit, they can apply for extension of time. They call extension of time.
They can apply for that.
Yes, extension of time for the period of MCO, which is from March to September.
Okay.
They have given a relief for developers to apply, but this goes on a case-to-case basis.
Okay.
Okay, and those developers who are expecting for CCC within this time period and they are not able to hand over vacant possession, so it goes on case-to-case basis. They can put in the application, and if there's a merit, an extension will be given for them. So for unlicensed developer, basically they must look at their own agreement to see what are the reliefs available. Which
so it depends on the contract itself for the unlicensed contractors.
Correct.
Okay.
So that's what really.
Understand. Florence. Okay. The next question. I mean, a bit tricky question. Okay. What if the property developer not able to get the EOT? Sorry. I mean, as we know that home buyers can claim for the LAD, okay, or we know as late penalty. So, any words from that?
Okay, so let us clarify a common misconception first.
Okay.
LAD is not a penalty actually.
Oh, okay.
Yeah, it's under Malaysian law, it's not enforceable, unfortunately. Right? So it talks about a genuine pre-estimate of loss that will suffer by the home buyers. So basically, it's about how much the home buyer is expected to lose per day if handling over of the unit is delayed. So we are talking about like LAD, and then we talk about it's not a penalty. However, home buyer is entitled to claim it as well. So there are tribunal for home buyers as well as court if the sum exceeds 50k.
Okay.
However, as you can see, all these are very time consuming. Like it's very costly too, because there are so many hidden costs, not only legal fees but consultant fees as well, like for us. And it's damaging for business relationship, because when you go against the developer like this, you are basically showing them that you don't want to settle this amicably. Like you are just going against them. So besides that, it's bad for business recovery as well, because for developers, if they need to keep solving all these issues, all these on-court issues, basically they don't have time to settle the main issue.
Itself,
the main issue, which is the house, it's not finished. So people need to remember that COVID-19 is a neutral event and it's not the developer's fault.
Understand. So what do you suggest then?
What I'll suggest is something that we call alternative dispute resolution. So ADR, it's called. So there's negotiation and mediation. These two are the methods I would suggest.
Okay, so basically, perhaps that you can explain further on what is ADR, or alternative dispute resolution, that you mentioned before.
Yeah, sure. So negotiation, let's start with that. It's basically two parties reaching an agreement of settlement. Settlement, it means that both parties are willing to work together amicably. Like both parties are wanting to solve it instead of fight against each other. So it's negotiation between two parties or their representatives. Like for example, I represent the purchaser and then Mr. Gana represent the developers. There's no third party involved. And then both parties should consult lawyers or consultants before settling, because they should be well aware of their rights and duties for matters. And then if both parties are willing to compromise on this situation, I would suggest negotiation. However, let us talk about the next one. Mediation. So mediation involves a neutral third party, you see. So the third party, the mediators do not take sides, they do not give legal advice, they do not provide counseling, you see. So there's no lawyers, no judge, no arbitrator. The mediator doesn't play all these things. He or she is basically there to assist the parties in searching for solution.
Understand.
So they will meet the parties face to face, or they will separately meet them in separate locations to ensure fairness.
So Mr. Gana, do you have any something that you want to say about this ADR perhaps?
ADR, I would say it will be a good strategy at this point of time, because you may have a lot of cases coming into tribunal, and there's a lot of legal case that are in making now, I would say.
Yeah.
So to have a quick solution on getting your matter resolved, I think we can look at ADR as an alternative to whatever provisions that we have within the sales and purchase agreement or the law. You see, but as far as the government relief to the upper tier developers and the companies, so in order to stop the legal action, at least for the MCO period. So the government in April has increased the threshold of demand notices from 10,000 to 50,000. Demand notices is basically for winding up.
Oh, okay.
Okay, so the period is now has gone from 21 days until end of the year for the developers to settle, or the companies to settle their debts. You know.
Oh, okay. It's something new.
Yes. Okay. So this actually provide some avenue for the developer to re-energize their business, and then to go into things like ADR. I mean,
and I would like to interject further with what Mr. Gana have said. So besides all the reliefs that Mr. Gana had mentioned, 21 days to 6 months, and then 10,000 to 50,000. So currently there's something we call the temporary measure for reducing the impact of coronavirus disease 2019. It's actually a bill, so you can search it online for more information for all of you. So this bill actually provides many type of reliefs, as we know. So firstly, for the developers, let's talk about it. So firstly, we have extension of the vacant possession time. So they can actually give the VP unit to the home buyers in the later time, because they get affected by COVID-19. They need time to actually finish everything before they can pass the VP unit. And besides that, there's a recalculation of the DLP date. So DLP is deferred liability period. So the DLP period throughout the month of March until like August, around that period, it will be not considered. It will be extended further. So they recalculate it
for that period only.
Yes, for that period only. But because that period is still like a few months time, so it actually helps the developer, because longer they can actually take care of their defect better. And then for purchasers also, there's benefits. So there's reliefs as well. So there is no late payment charges. Like the developers cannot charge them for late payment charges throughout the period of March to August as well. So you see, government is trying to work things out for both parties with this new bill when it's enforced. So, and the government also in the bill highly suggests mediation as a go-to method for settling disputes. So this is a government initiative, and we should, all of us, whether you are purchasers or you're developers, you should take note of it.
Okay, understand. So we will have a short break, so don't go anywhere. We'll be right back after this. Hi, we are back to discuss further on this topic, surviving in the COVID-19 economy as a property developer. So, Mr. Gana, so as a key management officer for a project and property management consultancy firm, so do you agree with what Florence have said before?
Basically, mediation requires consent and willingness of both parties to engage in that scenario, because you need consent from both parties. But it is a good strategy to try, because legal costs might be a burden to the purchasers or to the developers at this driving time. So ADR is an alternative that they can consider, and it would be equally provide the platform for both parties to discuss and come to an amicable situation. Because you may, if you are going on legal or whatever you may win a case against a developer, but I would not know the position of the developer to actually pay you if you wins a suit against them.
Okay.
Because end of the day, if a project get abandoned, then nobody going to benefit out of it. So no harm trying. I mean, if it's agreeable.
I mean, they can try if they want to.
Correct.
Yeah?
Correct.
Okay. So previously, I already threw a tricky question to Florence. Now, I just pass it to you. Okay, so does the current legal framework in Malaysia provide a solution for this situation?
Okay, developers which are companies. Actually, there's a provision in the Companies Act that allows a developer to engage on a more effective and more effective way of resolving their problem in the company. So we call that as a corporate rescue mechanism. Okay. So corporate rescue mechanism allow a company to go to a court to get some sort of relief to re-energize their business. Okay. So corporate rescue mechanism, basically we have 3 ways of doing it. Corporate voluntary arrangement, judicial management, and finally arrangement and reconstruction. So maybe companies can look into that and find a way to get their problem at the moment is resolved.
Okay, understand. So can you share with us, I mean, your experience in that restructuring for property developers before?
Okay, basically what we are looking at is arrangement and reconstruction, or for a matter judicial management. All the application is done and the restructuring is done through a court application and with a sanction of the court. Okay. Basically in arrangement and reconstruction, the company will appoint a scheme manager to prepare a proposal, which basically will be asking for some relief on the completion period, on the compensation associated with it. And then it will require an agreement of 75% at least from the creditors. Basically, purchasers are creditors by virtue of the SMP. They have paid some money.
They are creditors.
So simple majority.
Correct. So they have paid some money to the company. They are not able to get their property at the moment. The developer is in bad situation. They need some relief from the purchasers. Okay. So once the 75% is achieved, then you go back to court and then get the reconstruction or arrangement to be effected for a period which is agreed by the developer. So somehow it will provide some relief to the developer to arrange their financial and cash flow situation
and provide the compensation.
Correct.
Okay, understand. So when should they get help then?
I would say that for corporate rescue mechanism, I mean reconstruction, judicial management, arrangement of the companies, now is the best time to do it, because if you foresee after October that you might have some problem with your cash flow, you are not able to complete the project as agreed, so the developers may actually engage in corporate rescue mechanism, and at the moment the banks are very cooperative to this kind of ideas, and then they can try to get a solution to their financial problems.
Because banks want to work things out.
Correct. So for construction and rearrangement for licensed developer, of course they need to get approval from KPKT, Kementerian Perumahan,
dan Kerajaan Tempatan.
yes, Kerajaan Tempatan, so that to make sure that the project is completed as what they have planned, and whatever prayers, I mean whatever that the developer is asking in their reconstruction is not depriving the rights of the purchasers. So being the regulator, so they want to know what actually the prayers are all about.
So understand. So as a practitioner yourself, what you've been doing to address this issue? So perhaps at Florence, you as a claim consultant, can you share with us your plans? And I'm sure that audience also interested to know further?
So we are going to have a workshop coming soon, and it is open for all participants who are interested to know more about the subject matter that we are talking about today, namely debt reconstructing. So for those who are interested, you can follow our social media accounts, and please stay tuned as we're going to update more info on the workshop, how to register, and when's the date. We're going to update all of those.
Okay, so I mean, Mac consultant will update further on this.
Yes.
Yeah. So how about Mr. Gana?
Basically, at this driving time, people need help, developers need help. There's the issue on cash flow, loans, and all those things, So basically, we are providing some consultation and assistance to those developers who actually require their cash flow to be reorganized. So basically what we are doing is reconstruction and rearrangement according to the Companies Act. We are doing judicial management and the last corporate voluntary arrangement. All these items that we are doing is pursuant to Companies Act 2016, and somehow it will give them the breathing space,
Yeah, I understand.
all they need at the moment is breathing space.
Without all this pressure.
Correct. So they are able to solve their problem. If the unsold units are sold, I mean, most of the problems are settled. But at the moment, what they need is that breathing space. So we can provide them the avenue so that they can reorganize their business.
Okay.
So that's
thank you so much, Florence and Mr. Gana, for your time with us. So that's all we have for today's discussion. So Mr. Gana and Florence, any last inspiring words?
So at these trying times, everyone is suffering right now due to the COVID-19 pandemic. We are not just talking about developers, about purchasers as well as contractors. Many in the construction industry are going through tough times. So I think what we should do instead of going after each other's throat is to actually work out amicable solutions. Like what Mr. Gana and I mentioned, just that there are so many methods that you can look into, and we are encouraging you to look into it as well.
Okay. Mr. Gana?
I would say focus on your destination, not actually your problem. So if you can focus on your destination, I mean, you have planned something to be completed, and at the moment you are having some crisis, some problem. Get a doctor, I mean a consultant to solve your problem.
A doctor for this industry.
So,
construction doctors.
Get your problems resolved, and then once everything is okay, you are back to your business. So basically, that breathing space that we are providing.
Because we want business to thrive, right?
Correct.
Okay, understand. So thank you for sharing with us your thought and your ideas. So I'm sure that audience learned plenty from your answers. So thank you once again, everyone, for taking time with us for today. So again, don't forget to share this video as wide as possible. And thank you so much again. I'm Azlan Jaiz signing off. Bye-bye.
Thank you.
Bye.